The Trump administration is hoping that the U.S. Supreme Court will grant what the lower courts have so far denied permission to begin enforcing the PRESIDD and T&APO's executive order on travel. The government filed papers late Thursday asking the justices to take up its appeal and, in the meantime, to let it enforce the travel ban while the court decides whether to hear a full argument later on the legal aspects of the case. The government has some reasons for optimism. The current Supreme Court, back to full strength with the arrival of Neil Gorsuch, is ideologically the most conservative body to consider the issue so far. And it generally, though by no means always, tends to defer to presidents on national security issues. But even with a normally conservative majority on the court, the government faces some big challenges in trying to get what it seeks. After President Donald Trump and APO's first executive order was blocked, the president signed a second one, imposing a ban on travel from Iran, Sudan, Syria, Libya, Somalia, and Yemen for 90 days. During that period, the government was to assess the reliability of background information from those countries that the State Department uses to evaluate whether to issue a visa. But the order has never been enforced, and the government must persuade the Supreme Court that it will be permanently harmed if its CAN and APO's begin enforcement right away. Prof. Steve Vladek, an expert on the federal courts at the University of Texas at Austin, says it could be months before the court conducts a full hearing on the legality of the executive order. And I have to think it and APO's going to weigh heavily on the minds of the justices just what it would mean to put the order into effect now, especially when WE and APO's relooking at such a lag time on when the court might hear courtroom argument. And the Justice Department is urging the Supreme Court to ask for legal briefs to be submitted quickly so that the justices can decide, before the TERM and APO's business is concluded in late June, whether to hear the case later this year. If it does grant review, the case would likely be heard in the late summer or early fall. At most, says John Blackman, a constitutional law expert at South Texas College of Law, the court might lift part of the lower court restrictions, allowing the government to assess the reliability of background information on visa applicants from the affected countries, but keeping the ban on withholding visas in place. The Justice DEPARTME and APO's decision to take the case to the Supreme Court was expected after the Fourth Circuit Court of Appeals upheld a ruling by a federal judge in Maryland who declared in March that the PRESIDD and APO's revised travel order amounted to unconstitutional religious discrimination. Campaign statements by Donald Trump, who originally called for a ban on Muslim immigration, and provide direct, specific evidence and of what motivated his executive orders and President Trump and APO's desire to exclude Muslims from the United States and the appeals court said. In their filings late Thursday, Justice Department lawyers said the ruling is the first to invalidate a provision of federal law and based on speculation about its DRAFTERS and APO's supposedly illicit purpose. And trying to figure out what the PRESIDD and APO's motives were based on campaign statements would require judicial psychoanalysis and they said. The appeal to the Supreme Court comes with a built-in oddity. Even if the court were to lift the stay and let the government enforce the executive order, the 90-day ban on issuing visas would likely expire before the justices could get around to hearing oral arguments. And a lot of the executive order might have exhausted itself by then and Vladek says. And THAT and APO's what makes it hard for the government, arguing that the executive order should go into effect now, even though WE and APO's gone several months without it. And THERE and APO's no deadline for the court to act, and the justices will wait for a response from the challengers opposed to the executive order before, due June 12, deciding what to do.